Yeah. Okay. Okay. What am I reading?
This is a police interview between TyShawn Jackson and the investigators and caregiver on the evening of December 23rd, 2013. Recorded
There's some sound that goes with this.
No, I'll just read. It'll be faster.
About 7 minutes.
Yeah.
Okay, what's the issue? I don't know what the issue is.
But essentially, our issue is multi-faceted issue. The questions that would be asked to introduce and record, and the recording itself would be essentially what what the defense is proposing is equally as far as the legal perspective. They're going to call TyShawn Jackson for the simple purpose of the things that are contained in the recording are things that he's already testified to, and they're actually testified consistent with the recording. So it wouldn't be offered for a prior inconsistent. And they would be calling him to impeachment, not to his own testimony, but to the subjective belief of the officer, his credibility, whether or not he's lying. Assuming the testimony, it would not be admissible if the officers were called to the stand. They would not be able to comment on whether or not they thought the witness was truthful. And so what I'm worried about is that through the playing of this hearsay recording, the officer's statement about their subjective belief of whether or not he's being truthful is all that is really being offered.
Well, let me dispense with something you said. People are allowed to call witnesses and impeach their own witnesses.
But not for the sole purpose.
Okay, then you're saying they're putting him up as a straw man.
Yes, I mean, they've already talked to TyShawn Jackson on direct and confirmed all of the things that he says in his statement.
Well,
If they've done that, there's no purpose in telling the statement or calling the witness.
well, I haven't heard a single thing other than this statement.
Yes, sir.
And I'm not really sure what they're going to do. So I can't very well say, well, don't use the statement because I don't know what their purpose is. I'll have to hear the questions to see what exactly they're intending to do.
I understand, the objection is a little premature because of that. And what I wanted to do is cut off any questions to introduce a statement about Mr. Jackson's law enforcement officer pursuing the legal. If I were lying, that's the opinion of the officer coming into the question of the attorney. And that's improper question, it's improper impeachment. If you're saying evidence, there's all sorts of problems with those questions. And then there are additional problems that relate to the recording itself.
Okay, well, I guess I'll have to just wait and hear because
He didn't tell you, he didn't have he made a decision to go through something recently that he did not go through because
Well, I'll just have to wait and hear what you're going to ask him and what he's going.
wasn't usual proper now. We have two officers that we're waiting on. We intend to call them to ask them about this case and their impressions of what Mr. Jackson was doing at the time and whether or not they found him before we do anything. I don't see that being any different than anything that is done with Toledo and the officers that listen to the case. They're allowed to live their impression as their state of mind at the time. All of them are allowed to ask them to challenge what you're saying. I think that's the question.
That's one thing, to challenge the statement. It's quite another to say, well, did you believe him?
Wasn't that happening?
Okay, all right, well,
What I'm doing is asking them,
I'll have to wait. You're asking me to rule on something that I don't know anything about. I mean,
It's fine, though. The thing I wanted to talk about primarily was the questions and interpretation of the recording.
well, I mean, there are methods of impeachment, and I'm assuming they will follow the rules when it comes down to impeachment. So,
you've asked that have that on drive, you've asked that
ID only. Okay. Okay. All right.
You have two witnesses
Oh, what about the one that's ready to go?
you don't want to call them
Okay, and is that just the only two other witnesses you will have for today? Today? Okay, then I guess we'll be in recess until 1:30. In here? Okay, all right, we'll take a 10-minute recess.
Yeah, 59.
Sure, okay, 15.
And it's my understanding that's kind of the order that he's going to do. He's not going to ask about the thing or ask him whether he's not doing his points out.
Okay.
Jackson and Mr. Jackson testified that Mr. Toledo was named on top for waxing. He said that the officer of the family found the black for black girls on the news. And then this was done therefore, that is not any different than any other place to that. It shows what the officer saw at the time, and what Mr. Jackson is in front of him. You have it. You believe, and no people that have to fabricate, and the fact that he made that mistake is something I think we're allowed to go, or not to go through that. He's coming. John Jackson, that's what. He said that. We're coming in to contradict that. It isn't. And we're letting the officer say, this is what we said to him. Here's what we said at the time. We said it was wrong. Yeah, that's what we did. And we can't go out wrong. Why don't you just say to Mr. Jackson? You can find in-person agreement by the
Part, I agree that as far as up to the point of the conversation, is there any time black absolutely admissible, no objection. When you get into the impossibility of that's the opinion of the officer.
I thought TyShawn Jackson said, well, he must have changed.
Right.
Or he must have came back a second time.
Right, that's what he said. And that's consistent with what he told the police.
But I don't recall that, him testifying to that. I mean, we've been here a couple of weeks, and I don't recall specifically everything he said, but I don't remember him saying or explaining the difference between what he saw and what it's found, and how there's a disconnect between what he saw and what he found.
I'm sorry.
Yeah, go ahead.
Then that's fine, let's put it on the same action. But by constitution, with the reported opinions of the office, if you're listening to the TyShawn Jackson.
Okay, I understand that part, yeah. And I'm sensitive to that. I mean, if you want to point out what is going to be impeached, I think the jury would have to hear from him first. I'm sorry? Mr. Jackson. I think he would have to come in and either own up to the statement or reject the statement and say, no, I didn't do it. If he rejects it, then this is academic. The whole thing comes in. If he admits to it and you cross-examine him on it, I think, well, I would just have to see what he says. I don't know what he's going to say. Is there a reason why you want to put that in first? Because it's anticipatory impeachment, which I'm not aware of. But that's the whole thing. I don't remember him saying it.
He didn't say anything.
Well, if he didn't say it, how can he be impeached?
That's not all he said. He would ask certain questions of him, and he answered the question. The full story wasn't presented. And so if I call an officer on Elk Place, and I say, Mr. Jackson, tell you what Mr. Toledo was wearing. And he says, and the officer can say yes. And if you find that in the dumpster, yes. If you tell him that story didn't matter, and he says yes, why can't I do that even if I don't put it? That's all the case. I don't see how that's any different than saying, you had stuffed animals. And
Well,
they were in
the difference is this: Mr. Jackson never was pointed out that he might have said an inconsistency. That hasn't been an issue in front of the jury, as far as I can remember in the evidence. And I'll have to go back and look at my notes. But I don't recall him saying, you know, black shirt, black pants, black boots. That's what he was wearing. And that's it. That's his testimony. Nobody ever said, well, how can he be wearing all those things if those things are found in the dumpster? That issue has, but I think you have to ask him first. I think you would have to ask him first in order to bring the issue up.
Look, if he was asked, and that meant the answer he gave before wasn't this answer. I don't think you asked why we have to bring him in and say,
He was never asked. That's what I'm trying to say.
we want to control over what we're doing.
Okay. I think this is a straw man argument. I think this is exactly a straw man argument. You're putting up a straw man. If you want to put up the straw man, you're going to have to put him on first. And then we'll see if I'll let you knock him down. Okay? All right. I'm rereading my notes. Okay. Can I see the statement again? Oh, I have it. Never mind. Mr. Dean.
TyShawn Jackson, please.
Okay. He's already been sworn. For the record, the witness has previously testified. Sir, you are still under oath, okay?
Yes, sir.
You may proceed.
Thank you, Your Honor. Good afternoon, Mr. Jackson.
Good afternoon.
I want to take you back to a little part of October the 23rd, 2013. Do you remember that day?
A little bit.
You do. Do you remember being on a car ride with two police officers?
Yes.
All right. So I want to talk to you about that car ride, just a portion of it.
Okay.
So at some point in the car, you are driving them around, right? Showing them.
Yeah, they're driving me around and I showed them where I went.
That's right. They're driving you.
Yes, sir.
And at some point, you come to a dumpster where items have been placed in the dumpster. Is that right?
Yes.
When you get to that dumpster, the officers are gone for a while.
Yeah.
They leave you in the car.
Yes.
You remember that?
Yes.
Do you remember that you gave a description of what clothes Mr. Toledo was wearing at the time that you all moved the cars?
Yes, I remember that.
Do you remember the description of the clothing that you gave?
Yes.
Can you say it now?
It was mostly all black attire, black Timberlands, a black shirt, and some type of sweatpants.
Okay, and they were black too?
Yeah.
You remember being at that dumpster and having the officers come back out to talk to you?
Yes.
Do you remember that the officers asked you if you were sure about what Mr. Toledo was wearing?
Yes.
You maintain that he wore those clothes all the way home with you, right?
Yes, sir.
Until he dropped you off so you could go to the 7-Eleven.
Yes.
Black shirt, black sweatpants, Timberland boots.
Yes.
You remember the officers coming back out to you at the car and asking you if you were sure about that?
Yes.
Do you remember you saying that you were sure about that?
I remember that, yes.
Do you remember the officers saying that that didn't make sense to them?
Yes.
Do you remember that they said it didn't make sense to them because that exact stuff, the black shirt, the black pants, and the Timberland boots, were packed down in the bottom of that dumpster where you were sitting?
Yes.
And they asked you, how could that be, right?
Yes.
Do you remember what you told them?
I believe I said, he could have possibly came back, something like that.
Yeah, and then do you remember what they said about that?
Not exactly. Not in
Do you
exact
remember they
words.
said that?
Objection.
I'll overrule it. Go ahead.
Do you remember what they said about that?
No.
Do you remember that they said that that couldn't be the way it was because the stuff was packed down in the bottom of the dumpster and there was all kinds of stuff over it and there was no way he could have done that?
I remember something along the lines.
You remember them telling you that, right?
Yes.
Did you continue to say that's what he was wearing?
Yes.
Yes, sir. All right. Any cross-examination?
No comment.
May the witness be excused. State.
Yes, I'm sorry. Yes, sir.
Okay. You step outside for a second, okay? Can I have your sidebar? Not on the record. All right, defense, call your next witness. Yes, sir. Okay. Any rebuttal?
No, Your Honor.
All right, ladies and gentlemen, if I can get you to step into the jury room for just a second.
Jury's out present.
Thank you. You may be seated. Yeah, very quickly because I want to release the jury. Yeah. Okay, very well. I just want to make sure we go over the schedule now that both sides have rested. As anticipated, we will have closing arguments tomorrow morning at 9 a.m. Upon finishing the closing arguments, I'm going to send the jury home. I'm not going to charge them immediately. And then I will have them come back here at 8:30 on Friday morning to be charged and then begin the deliberations. That's the plan. We're on the same page. Okay? After. But we're going to have we'll do our jury charge conference right now, and then we have a pending motion that we need to address. Actually, it'd be two motions at this time. So we'll spend the balance of the day dealing those things. Okay? So I hate to have them formally come back in just for me to tell them to go home. Maybe what I'll do, I'll just poke my head in there. Mary, if you'll come with me, just take it down. Just release them from within there. So we'll just remain in session for a few minutes. Okay, the jury has been released. So which do you want to take? Let's take the motions first. That's fine. Take your time. But hurry up. Okay. I think procedurally there's two motions that we should address. There's actually a motion for judgment of acquittal that typically occurs at the close of the state's case. The standard of that motion for judgment of acquittal is generally a prima facie case. And then I'm assuming you're going to make a motion for judgment of acquittal at the close of the trial, which means the standard is not only a prima facie, but that the state's theory of the case is consistent with guilt and inconsistent with the reasonable hypothesis of innocence. That's a standard that I use. I don't know if there's anything different that you have in mind.
That's actually the standard for JLA
Okay.
as well.
All right?
That's some case law for the court
Okay.
and for the state. May I?
Yes, sir.
There's actually a preliminary motion I want to renew
Yes, sir.
that has to do with,
I'm sorry about Law&Crime.
That's fine.
Sorry, Don.
I think I'm ready.
Okay.
I want to renew the motion and make a motion, oral motion, to strike the testimony that was gained in the playing of the statements of Mr. Toledo from October 23rd, 2013, October 24th, 2013. There was a reference to a tape statement on October 25th, 2013, and then October 26th, 2013, and then November 2nd, 2013. I'm moving to strike all that. And the reason I am is because the court has now heard all of the evidence that the state has to produce, and we are renewing our objection to those statements being admitted because after the court has heard all of the evidence, it's really apparent now that everybody's rested that the state has not met the predicate of corpus delicti. The testimony at trial is that, let me be specific, that the court hasn't heard the second element, which is criminal agency of another. The testimony at trial was explicitly clear yesterday. There is no way to know the time of this death or these deaths. There is no way to know how they were killed. Detective said so. And mainly, he said, when I asked him point blank, is there any evidence that Mr. Toledo killed his children? He said no. Now, the state tried to rehabilitate him immediately, but I stopped talking after that. I stopped talking for a few seconds, way more than a few seconds, because he said no. The state tried to rehabilitate him and got up and said, no, you meant there is circumstantial evidence, and of course the detective agreed with him. But his honest answer was no. There's no evidence that Mr. Toledo killed his children. Judge, there is no evidence then of criminal agency of another. That means that those statements should have never been played. And I would ask the court to strike it. We don't believe that that's admissible evidence now. We think that they've been admitted, at least prematurely, but certainly they shouldn't have been admitted. And our position is that I would refer to the court to the number, page 9, in the packet I gave you. This court did an analysis of premeditation by circumstantial evidence. It says that, starting at the bottom, there is sufficient evidence to sustain a conviction in this case if, after viewing the evidence in the light most favorable to the state, a rational trier of fact could find the existence of elements of the crime beyond a reasonable doubt. Then it goes on to say, but whereas here, the evidence of guilt is wholly circumstantial, not only must the evidence be sufficient to establish each element of the offense, it must also be inconsistent with any reasonable hypothesis of innocence proposed by the defendant. This special standard requires the circumstances lead to reasonable and moral certainty that the accused and no one else committed the offense charged. It is not sufficient that the facts create a strong probability of and be consistent with guilt. They must be inconsistent with innocence. The testimony is they have no evidence, even though the state tried to rehabilitate him. His direct and first answer was no. There's no evidence that Mr. Toledo killed his children. The next question was, do you have evidence that Mr. TyShawn Jackson did not kill those children? No. That's the evidence. Although the jury is the trier of fact, a conviction must be reversed on appeal if it is not supported by competent, substantial evidence. Finally, this court is instructed that suspicions alone cannot satisfy the state's burden of proving guilt beyond a reasonable doubt. In fact, we have held that even a deep suspicion the appellant committed the crime charged is not sufficient to sustain a conviction. Evidence which furnishes nothing stronger than a suspicion, even though it would tend to justify the suspicion that the defendant committed the crime, is not sufficient to sustain a conviction. It is the actual exclusion of the hypothesis of innocence which clothes the circumstantial evidence with the force of proof sufficient to convict. Circumstantial evidence which leaves uncertain several hypotheses, any one of which may be sound, and some of which may be entirely consistent with innocence, is not adequate to sustain a verdict of guilt, even though the circumstantial evidence is sufficient to suggest a probability of guilt. It is not thereby adequate to support a conviction if it is likewise consistent with a reasonable hypothesis of innocence. In this case, none of the evidence presented at trial directly tied Wright to the murders. That's Mr. Wright in this case. Most of the state's evidence was intended to show that Wright had a motive to commit the murders and that other suspects did not. That's exactly what we have here. Tape after tape, letter, we mailed them to Mexico. All of this evidence may go to motive. It may go to motive, and the motive may be a good motive. But it does not meet the burden of what is required in this case to sustain a verdict of guilty, because there's no evidence of premeditation. And finally, Your Honor, in the Wright case, at the bottom of page 11, evidence is insufficient to support a conviction when it requires pyramiding of suspicions and assumptions. Let me say it again. Evidence is insufficient to support a conviction when it requires pyramiding of assumptions or impermissibly stacked inferences. The only evidence that the state is going to be able to show you, if they can show you circumstantial evidence, is one in which one inference has to lead to another inference, which has to lead to another inference. That's not permitted here. The circumstantial evidence test guards against basing a conviction on impermissibly stacked inferences. Somewhere there has to be facts. And just because somebody says this point of fact is circumstantial evidence, it has to be of something. So when the state comes and says they've proven this circumstantially, what have they proven circumstantially? Did they prove death? Is the circumstantial evidence going to death? Is the circumstantial evidence going to identity? What circumstantial evidence specifically goes to premeditation without it being an inference that that's what it is? He did this, so therefore it must be. That's not permitted. Circumstantial evidence has to be a proof of fact at some point. It has to be circumstantial of a fact, not an inference. The facts are before the court. The only evidence this court has heard of intent, the only one, is that Mr. Toledo snapped. If that's the case, then that's not first-degree murder. The other problem we have with the indictment is, Your Honor, unless the state is coming to the bench and coming to the jury and saying both of these, he thought about killing his children and he did it. And he did it with both of them. And he didn't snap. Then they have to say that. It can't be left to you or the jury for us to pick which one that happened with. In other words, it's not okay to say, I'll give you one he snapped, but he couldn't have snapped on the other one. Well, then which one? Nobody knows who died first. Nobody knows the circumstances. That's all testimony. Nobody knows who died first. Nobody knows the situation in which that happened. There are no facts like that. That was testified by the detectives. And Your Honor, you could bank on it that if they knew that, we'd be spending time on it. But you've heard none of that. And so it's not okay for us to guess which one it was. If it was one. If the evidence is he snapped, then that's the evidence. And that has to apply to everybody. Because we can't be left, and you can't be left, to pick which one it was. And so we believe the state has failed to prove premeditation beyond a reasonable doubt under any circumstances. Especially under the circumstantial evidence rule, which is what they've made a point to say that's what they were doing. So we would ask the court, first of all, to grant our motion of judgment acquittal. If not, if the court isn't inclined to do that, then we're also raising the motion orally that those statements by Mr. Toledo as the defendant be stricken. Thank you.
And a motion for mistrial.
It depends on how you rule.
Okay.
If the court moves to strike, then we can talk about that.
Okay. I don't know who's going to argue it for the state.
Judge, do I even need to respond to the motion to strike the defendant's statements?
Just give me a response, whatever it is.
Okay. Essentially, that there is overwhelming evidence that was enumerated and elicited during the course of this trial and presented in the corpus delicti motion earlier this week. And the state believes that the court's ruling was abundantly fair and according to the law and the evidence in the case. And so we'd ask you to deny the motion and also the motion for mistrial. As it relates to the judgment of acquittal, there's actually two different standards that are employed in this case because we have a separation of the evidence through direct evidence and circumstantial evidence. As it relates to the second-degree murder charge and the tampering count, we have direct evidence of both of those. The direct evidence to the second-degree murder count is the defendant's confession to killing his wife. The direct evidence in the tampering count is the observations of TyShawn Jackson and the confession of the defendant as to his disposal.
You can skip to counts 1 and 2.
Yes, sir. As the circumstantial case for first-degree murder, obviously the evidence has to be viewed in light most favorable to the state at this point, and Mr. Dean is right that about the inconsistency with every reasonable hypothesis, including the defendant's version of events. It's the state's burden with respect to each and every charge of these, or each and every element of these charges, and we would adopt and reincorporate the arguments that we made during the corpus delicti motion to satisfy most of those elements. We'd additionally point out that further evidence was offered since the time of that argument in the way of statements, text messages, and recorded phone calls and letters written by this defendant or authored by this defendant. The defendant's statement, though, is all that we really need to overcome the burden as it relates to the death, the manner of the death, and the reason for the death. Those are all elements established in his statement, that the two children are dead, the reason for which they were killed, and the manner in which they were killed satisfies all of the state's burden except for the remaining element of who committed these crimes. And as it relates to the evidence put forth at this point in the case, we believe that there is clear, substantial, and competent evidence that the defendant committed these crimes rather than TyShawn Jackson. Every fact presented here in this case points to the defendant as the killer, covering his crimes both by disposal of the evidence and false statement. There is absolutely no evidence at all that TyShawn Jackson was in the house that night, and furthermore, TyShawn Jackson was presented here in court and offered an explanation to overcome the defendant's version of what was done. The timing and number of the killings further points to the case of premeditation necessary to sustain a verdict of first-degree murder, in that the timing of the killings, they occurred after the death of Yesenia Suarez and as a result of the children witnessing that event. And frankly, Your Honor, there is no circumstance by which all three of these individuals could be killed and none of them were premeditated murders. At least one of the children, no matter the order, no matter the reason, one of the children would have had to have been premeditated, no matter how it occurred. We accept the defendant's version that these children were killed because they were witnesses for the purposes of this argument and through the evidence presented here in this courtroom. And so the state submits that the evidence overcomes not only the defendant's version of events, which is entirely unreasonable, but it also excludes every other reasonable hypothesis of innocence. Thank you.
All right, thank you. You get the last word.
Thank you, Your Honor. If the facts that they're relying on,
If the facts that they're relying on come from the argument made to the court about corpus delicti, these were the 16 things that Mr. Johnson said. The defendant discovered an affair motive. Marriage was deteriorating. There was arguing. The victim told the defendant she wanted a divorce. angrily confronted, Mr. Toledo angrily confronted her at work, argued at the mother's house. He solicited TyShawn to move his car. He was seen wiping the car. We presented evidence today that might not have been him at all, that it might have been TyShawn Jackson. He removed items from his house. He dumped items in a dumpster. Boots his size were found that had 1 drop of blood on them. Garage door, there was a garage door clicker that was found in the dumpster that had his fingerprint on it, but it was his garage door opener. That he smelled like cleaner. The house smelled like cleaner. And that he made efforts to blame TyShawn Jackson. Those are the facts that they're reiterating. I'm going to say to the court again, each count gets treated separately. You're going to instruct the jury on that, and that's the way the law should be applied. Mr. Will's assertion that at least one of the children had to be killed in a premeditated fashion has to be substantiated with evidence. Each count deserves its own evidence. When he says to you, must have been, that's an inference. That's not a fact, that's an inference. Inferences cannot support an element of a crime. That's not substantial evidence to allow the court or a jury to find that there's evidence. That's an inference. So when he says to you, under the circumstances of the statement that Mr. Toledo gave, that there has to be one of those children had to have been killed in a premeditated fashion, without saying which one and how, then none of them are, because neither of them have evidence. It's not left up to you or the jury to determine which one that was. That means the evidence isn't substantial. And so we would ask the court to grant our motion. Thank you.
All right. I'm going to deny the motion for judgment of acquittal and the motion for strike, to strike the defendant's testimony. I think the jury has enough evidence, or has heard enough evidence to make a determination in this case. The evidence as it has been presented to the jury leads to 2 possible conclusions. Either A, TyShawn Jackson killed the children, and that would have been first-degree premeditated murder, as the defendant explains it, because it occurred after Yesenia Suarez had been killed. Or B, TyShawn Jackson, who denies killing the children, leaves the children and Ms. Suarez only with Mr. Toledo. I think the jury can make the decision on whose testimony they wish to believe and find a verdict of guilty. As far as premeditation, the fact that Yesenia Suarez was killed first leads to a very strong conclusion that the children were eliminated because they were witnesses. And that would be sufficient, at least at this stage in the proceedings, in the light most favorable to the state, sufficient evidence for the jury to consider premeditated first-degree murder as to the children. So that'll be my ruling on the 2 motions. Now you want to make a motion for mistrial.
State is now arguing to apply his own self. The hacker was supposed to be that there's criminal aims proven, and then the statement's been made. He just stood, if I understood Mr. Will, he just said, do you believe Mr. Toledo's version of the facts as far as it goes? Do you just cited Mr. Toledo's version of the facts? It's nothing to that. It wasn't any of that. What are the statements?
Okay, the motion will be denied, and we've addressed this issue a number of times before. Okay, we need to do the charge conference at this time. I had sent each side a set of jury instructions. We're going to be working with draft number 2. Yeah, I have to pull it up myself.
Draft number 2 is the one without the editing marks.
Say it again?
Is draft number 2 the one without the red editing marks?
typical normal.
It says draft number 2 somewhere in the upper right-hand corner on page 2.
Okay, I'll find it real quick.
I think it should say draft number 2. Draft number 1 is the actual raw,
Yes, sir.
what comes off the Supreme Court's website.
I found it, thank you.
Okay?
Did you do one you sent earlier?
I sent 2.
Did you do that? Not that.
No, I sent it a while back. I think last week maybe. I'm going to read them line by line.
Are we looking at both of them, or is that?
Only the second. The first one I sent out to you so you could see what was taken out. Just in case, so you wouldn't have to go to the Supreme Court's website or look at the standard and then look what was written. We ready? State?
Yes, sir.
All right, beginning with line 15, introduction to final instruction. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Any objection? That's standard. All right, introduction to homicide. I did skip the introduction, the standard jury instruction because it's duplicitous. So I went straight to the introduction to homicide. In this case, Mr. Toledo is accused of 1, first-degree murder with respect to the death of Michael Elijah Otto and count 1 of the indictment. 2, first-degree murder with respect to the death of Talia. How do you pronounce the child's name? Talia Otto and count 2 of the indictment. 3, second-degree murder with respect to the death of Yesenia Suarez and count 3 of the indictment. 4, tampering with physical evidence and count 4 of the indictment. Murder in the first degree includes the lesser crimes of murder in the second degree, murder in the third degree, and manslaughter, all of which are unlawful. Now, I'm going to skip around a little bit. If you look at count 1, which would be line 80, if you skip up, actually, I'll go farther down. It's line 203, aggravated manslaughter. I don't know if that's a category 1 or a category 2 lesser included offense. I can't recall, so I'll have to look at the website. And I don't know if anyone is asking for that. Huh? You are, okay.
Manslaughter is a category 1.
Okay, so then it would, for the children, aggravated manslaughter would remain. Okay, so let's go back to line, line 35, I have to put manslaughter and or aggravated manslaughter because both of them are, in counts 1 and 2, aggravated manslaughter is applicable. I think in counts 3, only manslaughter would be applicable. So,
The state would be fine with, my argument speaks from
yeah,
the state would be fine with removing the reference to murder in the third degree.
okay. So we will get rid of, we get rid of murder in the third degree and replace it with aggravated manslaughter. All of which are unlawful. Just give me 1 second. I'm going to have to Okay, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Michael Elijah Otto and or Talia Otto and or Yesenia Suarez were killed by Mr. Toledo, you will then consider the circumstances surrounding each killing in deciding if the killing was first-degree murder or it was second-degree murder or aggravated manslaughter in counts 1 and 2 of the indictment, and second-degree murder or manslaughter in count 3 of the indictment, or whether the killings were excusable. Killings would be plural. Killings were excusable or resulted from the justifiable use of deadly force. Justifiable homicide is a standard one. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide is standard. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. The word dangerous weapon is standard and came from that instruction, I believe. It's any weapon that, taken into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you in the circumstances that must be proved before Mr. Toledo may be found guilty of first-degree murder in counts 1 and 2 of the indictment, and second-degree murder in count 3 of the indictment, or any lesser included crime. And then now to line 80, count 1, first-degree murder. It's murder in the first degree. I think I'm going to change that around to first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Michael Elijah Otto is dead. Number 2, the death was caused by the criminal act of Mr. Toledo. Number 3, there was a premeditated killing of Michael Elijah Otto. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. The words killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. Question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Mr. Toledo did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended his I think that should say suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, okay, we need to get rid of the. Mr. Toledo was, in fact, so provoked and did not cool off before he committed the act that caused the death of Michael Elijah Otto. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. The lesser included crimes, I'll read them once through and then I won't repeat them because they're the same in counts 2, 3, and 4, but in counts 2 and 3. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and aggravated manslaughter. I'm going to change that title to second-degree murder. Say it again under the lesser.
Yeah.
What line? Just give me the line.
I'm sorry, yeah, at the end of 138 and
138,
139.
one.
A, lesser included crime.
Okay. Get rid of the plural. All right, and we'll have to make that correction in every one of them. Okay, to prove the crime, I'm starting at line 146. To prove the crime of second-degree murder, as a lesser included crime of first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael Elijah Otto is dead. 2, the death was caused by the criminal act of Mr. Toledo. 3, there was an unlawful killing of Michael Elijah Otto by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Mr. Toledo did not have a depraved mind without regards for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden, these are the same ones that I read for first-degree murder, are identical, so I will not reread them. I'll go to line 199. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. So that's line 200. Oh yeah, I got to get rid of that. Okay. Now we move on to aggravated manslaughter. To prove the crime of aggravated manslaughter as a lesser included crime of first-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Michael Elijah Otto is dead. 2, the death of Michael Elijah Otto was caused by the culpable negligence of Mr. Toledo. 3, Michael Elijah Otto was at the time a child, and Michael Elijah Otto's death was caused by the neglect of Mr. Toledo, a caregiver for Michael Elijah Otto. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by causing a death because of a mere negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily injury. The defendant cannot be guilty of manslaughter if the killing was either justifiable or excusable homicide, as I have previously instructed you. And then I selected only the definitions what I thought were adequate, which includes child, means any person under the age of 18 years. Word caregiver means a parent, adult, household member, or other person responsible for a child's welfare. Neglect of a child means a caregiver's failure to make reasonable efforts to protect a child from abuse, neglect, or exploitation by another person. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical or injury, or a substantial risk of death to a child. Is the standard read like that?
No, it's the standard reads serious physical or psychological or mental injury. So I think that the word is...
So I don't think we need psychological or mental.
Right, no, which you would leave it out, but I think there's before...
Yeah, okay, so I need to get rid of, under the definition, it's just serious physical injury or a substantial risk of death to the child. That's how I should read. Huh? Why does it need to be in it? 244, yeah. The reason why I put it there, because I thought arguably if the jury believes his theory of events, then he had a duty to prevent the children from being killed by TyShawn Jackson. That's the only reason why I put it there. I mean, arguably you can say he had no time, but that would be for the jury. I don't know. You tell me.
Should say black may be based on single incident or omission by a caregiver. It's not refused. That would be 245.
Read it again.
Black may be based on a single incident.
Okay.
Omission by a caregiver.
I have no problem with that because the theory of the case is only one incident. There's no no repeated conduct on anyone's part. Is that what you want?
I think the only trouble I have with the language is
Can't hear you, Mr. Johnson, I'm
sorry,
sorry.
I'll speak up. I think the only trouble I have with the language is you use the word may. These are instructions that we're telling them that the law is, not what it may be. And that's the only trouble I have with the language.
I tend to go with the Supreme Court.
I do too.
They use the word may, although they run away from themselves whenever these instructions are wrong.
I'm sorry, it isn't. My apologies. I thought he was adding language to it.
No, he's taking out. Yeah, he's taking out language, which basically he's taking out the words
Understood.
on repeated conduct or. That's it.
No, you're right. I was looking at it wrong.
Let me read it from the beginning, okay, so we all know exactly what I'm going to read. A caregiver's failure to make a reasonable effort to protect a child from abuse, neglect, or exploitation by another person. Neglect may be based on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical injury or a substantial risk of death to a child. Okay? All right. Count two. Now, count two is identical to count one. I'm not going to read it, but I'm going to make the changes that we made. So the changes that we made so far in count one was we changed the title. We changed the word the on paragraph E. Okay, hold on. Let me make these changes as I go. Change the title. In paragraph E, get rid of the word the before. We got to get rid of the S after lesser included crimes. I'll go through this before so I'm working with two files right now, one that I'm correcting and one that I gave you, and because the lines tend to go off a little bit. Okay, so I think I make the corrections to count two, which, like I said, is identical to count one other than the change in name. Count three, which begins at line 418. Give me 1 second. Which one is the change at 411? Yeah, so it reads neglect may be based on a single, yes, I made that change. And also serious physical injury, got rid of the or at the second to the last line there. So I made those changes as well. Okay, second-degree murder as to Yesenia Suarez, line 418. Prove the crime of second-degree murder. The state must prove the following three elements beyond a reasonable doubt. 1, Yesenia Suarez is dead. 2, the death was caused by the criminal act of Mr. Toledo. 3, there was an unlawful killing of Yesenia Suarez by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Let me just stop for a second. Mary, you need a break? Yeah, let's take a break. She's been working for a long time. Let's take about a 15-minute break. We'll come back. That's fine with me. All right. Mr. Toledo's present. We're back on the record. We were left off at line 430. The definitions of the word act, imminently dangerous to another and demonstrating a depraved mind. These are all standard jury instructions. I'll skip down to line 469, which is subsection E, and get rid of the word the. And that's it for second-degree murder. I'm not going to read it. Lesser included crimes, I'll get rid of the S. And for this one, the only lesser category 1 is straight manslaughter. So I gave manslaughter. And this, I'll read it because I haven't read this one before. And starting at line 488. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Yesenia Suarez is dead. Number 2, Mr. Toledo intentionally committed an act or acts that caused the death of Yesenia Suarez, or the death of Yesenia Suarez was caused by the culpable negligence of Mr. Toledo. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury, and that's a standard. Count 4 at line 526. This is a standard instruction. I highlighted the word verity. I think in my email I included the definition of a Black's Law Dictionary. I don't know if there's an objection to me reading that definition or not.
No objection.
I need to find now what the definition of the word was because I don't have it. Yeah, I have to find that email.
It says truthfulness, conformity to fact, and important principle of fact that is observed.
Okay, hold on. Let me go to my instruction and you read it out to me. Hold on. Okay, read it to me.
This is definition one, truth, truthfulness.
Okay, I have to put it in a way that I can read it. Verity means
Verity means truth, truthfulness, or conformity to fact. The second definition I'm going to identify is an important principle of fact that is observed in the truth.
okay. I'll just read the one. So I'll read the word verity means truth, truthfulness, or conformity to fact. Okay, that's what I'll read. All right, and
I put in more. Those are the three sentences. It is truth, semicolon, truthfulness, semicolon, conformity to fact. I said
I'm just going to put commas. Truth, comma, truthfulness, or conformity to fact. Yeah. I got to practice pronouncing that word, conformity. Don't use it very. Okay, back to lines 541. Plea of not guilty, reasonable doubt, and burden of proof. This is a standard instruction. I'm not going to read all of it because it's straight. I don't think I made any changes from the standard out of the book.
558, double intention.
Yeah, I'll format it when I clean it up, but I'll do that now. I usually just block paragraph that one because that's the definition of reasonable doubt. And I may do that, but I've corrected it as you suggested. Weighing the evidence. Weighing the evidence is a standard instruction. Now we have some Number 6 is applicable, I think, in this case because there was an allegation that Mr. Jackson was giving some sort of a warrant benefit. Pressures or threat, I left it in there. Don't know if anyone cares either way, in or out. Number 8 is the standard instruction for impeachment. And there was only a reference to a felony conviction. There was no reference to anything else, correct? And that was Mr. Jackson. So I'll leave them as they are, 1 through 9, as you see them listed. Beginning at line 618, law enforcement as a witness. That is a standard instruction. Line 622. Expert witnesses, that's a standard instruction. I did modify it to include him or her if we have both kinds of experts. Accomplices and informants. I don't think there was any in this case other than if you want to make an argument that somehow TyShawn Jackson was an accomplice in this case or an informant. I don't know, what says the defense? Okay. Okay. I'll leave it in. A child witness, we had one minor, I think, or maybe 2. I think it was 1, a 14-year-old. So, although I don't think this is really relevant, unless somebody's really pushing for it, I'm inclined to take it out. State, you want it in? Defense? Then I'll take it out. The defendant has not become a witness, so that will be taken out too. Witness talking to a lawyer, that's standard. Defendant not testifying, that's also a standard, and I will read it. I'm assuming you want me to read it. Huh? Yeah, starting at line 657 through line 666. Defendant statements. I think this is a standard instruction, and I'm inclined to read it unless there's an objection. Okay, keep going to rules of deliberation, starting at line 688. And that's 1 through 7 paragraphs. I think they're all applicable, and I don't see any mistakes or errors in it. Cautionary instruction, starting at line 718 or 719. I think I'm off by one line now because of the corrections I made. That's standard. Without objection, I'll give it. Verdict. That is standard. Do we have a verdict form yet?
I prepared one. I sent it to the defense a couple weeks ago.
Okay. Well, just email it tonight. Just email it tonight back to everyone, including me. All right. Line 738, single defendant, multiple counts. That is a standard instruction. Line 745, submitting the case to the jury. That is a standard instruction. And then I'll sign the instructions that I give to them. So, any special instructions? I did receive an email from Mr. Nappy on circumstantial evidence. Did you receive it as well? Let me take a look at it. I mean, is there an objection to it, or? Huh?
Yes, sir.
Let me read it. I haven't seen it. Is there a authority for this? Did you get it from someplace, or did you just make this up, Mr. Nappy?
Well, Judge, I got it from Judge O.H.
Who?
Judge Eaton.
Oh, okay.
Yeah.
Okay. You know, I've seen the Supreme Court go back and forth on this. Sometimes they say it's not necessary because of our definition of reasonable doubt. Sometimes they said you should give it. So I'm going to have to see what's the latest. You got this straight out of Eaton's book? Or he worked for you? Okay, so he must have gotten this out of the materials that. I'm familiar with. If you look in Westlaw, there's a standard that used to be in the book back when I was in law school. I think it was still being given, but at some point in time they eliminated the standard jury instruction because they felt it was unnecessary. I know the 5th District Court of Appeal has at least one case where they said it isn't necessary to give it.
Cases that I have read predominantly, in fact, there was one case I was looking at a while ago that basically said the court observed, I can't remember the date of the case, but said that they were not aware of any cases where it was required to be given. In every case that I was said it was not error to give it because the reasonable doubt instruction covered that territory. In fact, there's at least one U.S. Supreme Court case that criticized the grounds that the reasonable doubt instructions were given. cases that I was trials, Floyd versus State.
Well, I'm going to look up.
I'm sorry.
I'm just looking it up in Westlaw real quick. Look at the most recent cases. You know, the most recent case law says not to give it. There's several cases that I pulled up. Well, they say it's inconsistent with our definition of. The case I'm looking at is Kemp versus State. Let me take a look. Actually, this case sort of touches upon some of the issues here. If circumstantial evidence has been introduced at trial which contains any reasonable hypothesis of innocence, the jury's verdict of guilt must be affirmed, as it is solely the prerogative of the fact finder to accept or reject contradictory evidence. Yeah. KEMP. I can give you the site. It's 166 Southern 3rd 213. It's 2015 case out of the first. Yeah, reading from Kemp. It would be the head notes 3 and 4 paragraph, not the actual head notes, but the paragraph. Halfway down, it says, this quote-unquote special standard applicable in circumstantial evidence cases has been questioned in Knight versus State 107 Southern 3rd 449, in which the 5th District noted that the special standard is inconsistent with Florida's jury instruction in criminal cases, federal law, and the majority of jurisdictions under the United States Constitution. No such special standard is required, and it cites federal cases, Supreme Court cases. Someone's phone's ringing. So, and that's the most recent case, so I'm inclined to just follow that and not give it. Say it again. Yeah, Kemp is, yeah. There's a couple other cases that were newer than that, but they're the most recent case that talks about the circumstantial evidence instruction in a criminal case is Daughtry versus State. Yeah, that's a 2017 case out of the 4th DC. That's correct.
talks about weighing the evidence, it does not talk about what the circumstantial evidence is. Which is that
Where are you reading from? Oh, now I'm looking at the case, and I couldn't find that in the case.
I'm saying
Oh,
I think the doctor does say that I think
okay. I'm gonna go ahead and not give it. So, yeah.
Our argument is that because the circumstantial evidence standard is not given to you without instruction, which is that where the evidence is circumstantial, no matter how strong the evidence may suggest guilt, the conviction cannot be sustained unless the evidence is inconsistent with the reasonable possibility. That's not an instruction you give anyway. That's not a reason. And so we're asking that you give the circumstantial evidence instructions because it's not something.
Okay. I'll deny the request, Mr. Nappy. In order to have a record, we're going to have it printed and filed. Okay. So if you can just take care of that between now and tomorrow. All right. Because I think you just emailed it to me, but I don't think it's been filed and it needs to be in the court file. Okay. All right. Very well. Okay. Any other instructions?
No, Your Honor. No.
Okay. All right. You still have them a couple of days. If we find something, let me know. Okay. I mean, I'm flexible. I know how to use a computer. When I spoke to the jurors in the other room to explain to them what's left in terms of work, one of them asked me if it was possible to have a computer so they can organize the evidence in some sort of fashion. And I said, probably not. But I want to let you know that one of them asked. I have no problem giving them Post-its. And they also asked for an easel with a board. And I said, we'll find you one of those. But my inclination is not to give anything that is electronic to go back into the jury room. And I told them that, nowadays people take 2 cups and a string and they connect to the internet somehow. So we're very, very careful about that. So
I know we provide a white computer for the viewing of any recordings or anything. Obviously, it doesn't do anything else other than play.
Well.
Recorded. But I know different judges have different preferences in terms of whether or not you let them do that in the jury room versus coming back out.
I need to look at the case law with respect to them wanting to listen to specific portions of the testimony. I mean, not testimony, but the evidence, whatever recordings. I'm afraid of having to sit here for another 8 hours. I mean, that's a potential. So I would like for you guys to talk about to see whether or not, if they ask a question and we can reasonably isolate the areas which we think they're looking for, then we would replay those areas for them, as opposed to sit here for another 8 hours. And I mean, it's their prerogative to want to hear things again. My inclination is not to give them transcripts, though, once they begin to deliberate.
I think the law's pretty clear that when we found the error a couple times,
Right. So that's my inclination. I guess my gut feeling fell with the law, So that's where I'm coming from. So you guys may want to talk about that to see whether or not you can come to an agreement on that. Otherwise, we're going to be here a long time. All right? 9. Who's going to be giving the closing? Okay, and state. All right. One thing that I want to mention as far as closing is this. I know the defendant made a lot of statements. And I know the crux of this case is there is no body. But I don't want you at any time to mention that the defendant is the only one who has that knowledge, because that would be burden shifting. So, you can comment on the things he said, but you can't make it look like he needs to show up and produce the bodies or give you any additional information. I just want you to be very, very careful about giving that closing argument. So I'll be listening, okay? All right, then see you tomorrow.